And in my 19 years of legal practice, I have focused exclusively on helping businesses and management avoid, defend, and resolve workplace disputes. My Wilson Turner Kosmo colleague Corinne Phillip and I are happy to continue that trend with thanks to the San Diego chapter of the Association of Corporate Counsel as we present Bots, Bias, and Boundaries 10 Workplace AI Realities In-House Counsel Can't Ignore. We will spend the next 45 minutes or so laying a foundation we hope will help you think critically about how your businesses use, oversee, and communicate about AI from an employment law perspective. We will cover California regulations and other published guidance in this quickly changing landscape and work to raise awareness about areas of risk as well as opportunity to mind the bots and keep them in their boundaries so they don't get you into an untenable amount of trouble. Please feel free to send questions via the chat, but remember this presentation will be recorded. We will have time for discussion at the end and look forward to hearing your feedback after the show. Keep an eye out for your continuing legal education credit, which we very much appreciate the ACC's Aubrey Marlowe for helping us provide those in attendance. Now, Corinne, we are ready for workplace reality number 1.
So reality number one is that, like it or not, AI is here. Almost half of employees in your business are probably using AI at work. If your business does not have an established AI policy in place, you probably have an AI black market. A Talker research poll conducted last summer surveyed 1,000 US businesses, owners, marketers, and salespeople. And back then, 20% of respondents said they've had to sneak AI into their jobs because they have no formal guidance or approval from management to use it. Employees feel the need to use AI to compete and feel more confident when they use AI. According to this poll, employees claim to save 13% of their work time, but that number has likely increased exponentially since this poll closed last June. We would love to hear from you about how much AI is replacing jobs where you work, but clearly a significant number of employees have concerns about their job stability. On the last point here on the slide, where 19% of respondents indicated last summer they believe customers might lose trust if they found out AI was being used in their businesses. Those concerns can be addressed with good AI policies, training, and well-planned communications, but the law is catching up. For now, what risk is AI creating from the employment law perspectives? First, let's make sure we're all on the same page with what AI is and what it can and can't do.
As you likely know, generative AI can create coherent human-like responses to questions or prompts, but the tool is not actually intelligent. It takes your prompt and predicts what words are most likely to come next based on patterns learned from large language models or LLMs, text data fed to the tool to train it. There's no guarantee that two people using their own prompts or different tools filled with unique data will get consistent results, especially on questions further from common knowledge. Many models cannot tell you how or why they produce specific results, which poses serious problems for in-house counsel. As lawyers, it's important we know and cite our sources.
Many of us are also probably familiar with the AI risks. Some AI combines true facts illogically. At times, AI makes up its own facts. And we have people talking into echo chambers, hearing their subjective realities back. You or your employees may also be struggling with societal and environmental considerations when using AI. I will admit that I struggle with that. But reality number one is that AI is here and we want to help you embrace it, but only while using our critical human thinking, protecting employee, consumer, and customer data privacy, ensuring privilege protections, and staving off employment liability risk to the extent that you can.
There's more to reality number 1. When AI goes wrong, who is to blame? The reality is that might be you. California's Artificial Intelligence Related Harms Act took effect on January 1st, 2026, and eliminates any defense in civil actions that AI acted autonomously or that a third party is solely responsible for its mistakes, meaning your company, as a user of AI, would be liable for harm caused by AI systems. Just like you cannot offload joint employment responsibility by contract delegation to a temp agency, you can't avoid employment liability by delegating to artificial intelligence. If you or your business are going to use it, you better understand how it works because you will be responsible for what it does. While this is not a presentation about legal ethics, because you're all lawyers, I feel compelled to note that your use of AI raises myriad ethical considerations in addition to those relating to employment. You're all bound by the 9 duties you see on your screen, and all of them are implicated by lawyers using AI for work. Some of these ethical duties find their way into others of the workplace realities that we're here to discuss today. But for more information about the ethics of using AI as lawyers, California State Bar published a set of guidelines linked here in our presentation materials regarding the ethical use of AI. These don't hold the force of law, but they are best practices for using AI for lawyers in the state. The ABA also published Formal Opinion 512, which goes into even more detail about the ethical use of AI generally, but similarly is advisory. In my opinion, both of these documents should be standard reading for AI-informed lawyering. But for now, to summarize, reality number one is that AI is here, it's here to stay, and the law is going to hold you and your businesses responsible for the fallout. With this in mind, we are ready for reality number two.
So data insecurity, this is a big one. You saw that something like 1 in 5 survey respondents are using AI at work secretly. So what if Dale in sales decided to upload his targets, hits, and misses to impress the regional manager with a dynamic presentation of his portfolio? Would the presentation be awesome? Maybe. But Dale might have inadvertently divulged sensitive company data, confidential customer or employee information, or even privileged communications. Employees have no way to control what a large language model does with the information they put into it. Depending on the tool used, we should expect the data to be retained by the LLM, used to refine future responses, and be exposed to others. Employees should know that, like social media, if you do not want anyone to see something, you do not feed it into a bot. They might do it anyway. So, what can you do? Develop a comprehensive AI policy that reflects a deep understanding of how your chosen generative AI tool works. Consider using a closed platform and train all employees on your policy thoroughly. Ensure employees understand your data security policy and your constituents' data policies, and train employees on the right way to use AI if you decide to allow it.
Workplace reality number three. AI powered hiring tools like resume screeners and video interview analysis can and do perpetuate or even amplify existing biases. LLMs rely on real world text that reflects the real world biases, stereotypes, or other imbalances of the creators of that text. So if certain ideas, perspectives, or viewpoints are over or underrepresented, or even misrepresented in the training data, the model can produce unfair outputs, either intentionally or unintentionally, reinforcing biases and stereotypes. Again, as with other employment obligations, we can't pass off our duties to avoid lawsuits. And if we're going to be using the bots, we need to take all reasonable steps to keep them within their lawful boundaries and avoid bias in the use of algorithms. More specifically, workplace reality number three is that employers should anticipate increased legal scrutiny and potential class or collective actions as regulatory bodies and courts continue to address the implications of AI in employment decisions. The importance of consulting an attorney before deploying AI systems in hiring and HR processes can't be sufficiently stressed. I can tell you that many of our clients are concerned about this after a case called Mobley v. Workday, wherein the court conditionally certified a class of plaintiffs claiming they received hundreds of rejections without interviews after applying for jobs through Workday. Allegedly, Workday's AI-driven application filtering algorithm disproportionately disqualified individuals over 40 from employment opportunities. Workday represented in discovery that 1.1 billion applications were rejected using its software during the relevant time period, making this what could be one of the largest collectives ever certified. We're certainly keeping an eye on it. Cutting to the chase, Corinne will start us off on how California's Civil Rights Division is crafting the lens through which AI employment actions will be viewed when challenged on individual, class, or collective bases.
So, because of the potential bias involved in using AI, the California Civil Rights Department, which promulgates regulations that implement California's civil rights laws, published a new set of regulations concerning AI in the workplace. Among other things, the regulations clarify that it is unlawful for an employer to use an automated decision system, or ADS, with selection criteria that discriminates against applicants or employees based on FEHA protected classifications. Now, to understand how these regulations apply, we need to understand what qualifies as an automated decision system. The regulations define automated decision systems pretty broadly. It is any computational process that makes a decision or facilitates human decision making regarding an employment benefit. This includes obvious AI tools like resume screening software that ranks candidates, but also simpler systems using basic algorithms or statistical models. So, a few common examples could be computer-based testing and assessments, systems that target job ads to specific groups of people, software that analyzes your facial expressions or voice patterns during video interviews, and tools that screen resumes for keywords. The point is this, it's not just advanced AI that qualifies. It includes any automated tool that helps make employment decisions. So even that simple software that automatically sorts resumes by GPA or years of experience could be covered. On the other hand, not all technologies fall under this definition. Basic software like word processors, spreadsheets, firewalls, or data storage solutions are excluded unless they are specifically being used to make employment decisions. So here's a simple test to remember. If a computer system is helping you decide who to hire, who to promote, or who to discipline, it's probably covered by these regulations. Oh, Amy, you're muted.
Thank you, Corinne. The regulations unsurprisingly make clear that employers cannot use automated decision systems that discriminate against applicants or employees based on protected characteristics under the Fair Employment and Housing Act. But they go further into the ban of use of proxies. What is proxy discrimination, you may ask? It's an indirect way of discriminating, and this is where many employers could accidentally get into trouble. A few real-world examples. If your AI system automatically rejects candidates from certain zip codes, and those zip codes happen to be in predominantly minority neighborhoods, that's proxy discrimination based on race. The system isn't explicitly saying reject all Hispanic candidates, but it could achieve that same result based on using zip codes as a stand-in. Or if your facial analysis software rates people differently based on their appearance, that could be proxy discrimination based on race, gender, or disability. These systems might think they're measuring professionalism or enthusiasm or attention, but they could actually be penalizing people based on how they look or move. The regulations also strongly encourage employers to
Hi,
conduct anti-bias
I'm just
testing
been
in
trying
their
to get
AI
field credit while I'm
systems.
eating my lunch.
We have somebody that needs to mute. Audrey, if you could help us. Thanks. What testing might look like, consider your resume screening tools. One effective method is the twin resume test. You take two resumes that are identical in qualifications, skill, experience level, and you change only the names. Submit one as, for example, Michael Johnson and the other as Miguel Rodriguez. And if your AI ranks these resumes differently based solely on the name, that's a red flag. It's clear, it's a clear signal that bias has been baked into the system and it needs to be addressed. Or consider your video interview tools. Here you can have the same person record identical responses to the same interview questions, but between recordings, vary the lighting, background, outfit, hairstyle. If your AI assigns different scores to the exact same answers just because of some of those visual changes, you're not measuring qualifications. Instead, you're measuring appearance, and that causes a bias problem. Now, while anti-bias testing is not mandatory, if you get sued for discrimination, the court will look at whether you tested your systems for bias, the quality of that testing, and how you responded to the results in terms of whether you took all reasonable steps to ensure the elimination or the non-existence of bias.
The regulations also include extensive amendments to existing rules regarding pre-employment practices, an area where many employers are using automated systems. First, the regulations prohibit using scheduling-based filters that can disadvantage those needing religious or disability accommodations. The new regulations clarify that even ranking candidates by schedule can be unlawful unless job-related, required by business necessity, and accompanied by a clear accommodation process. Second, the regulations prohibit using assessment systems that penalize individuals with disabilities, and employers must offer reasonable accommodations or risk violating FEHA protections. Third, the regulations prohibit using biometric analysis systems that reflect protected characteristic biases. Systems analyzing tone of voice, facial expressions, or physical characteristics during interviews can discriminate based on race, national origin, gender, or disability. Employers must evaluate whether those tools are necessary and whether less discriminatory alternatives exist. Fourth, the regulations prohibit using automated systems for unlawful pre-employment inquiries. So, if a question about criminal history or other topics would be illegal in a traditional interview, it's equally unlawful when embedded in an algorithm. Additionally, some automated assessments may qualify as medical or psychological examinations under California law, particularly those eliciting information about mental or physical conditions. These are subject to strict legal standards, requiring them to be job-related, consistent with business necessity, and that no less discriminatory alternative exists. So the bottom line here is the use of automated decision systems in pre-employment screening is no longer a gray area. Employers must treat these automated decision systems as regulated employment practices, subject to the same scrutiny, accommodation requirements, and anti-discrimination standards as any other hiring tool.
The regulations also create two major changes affecting all employers, one involving compliance obligations and another involving liability exposure. First, extended record keeping requirements. All employers now must retain personnel and employment records for at least 4 years. This applies to all records, not just AI related ones. So even if you never use AI, you must update your document retention policies. And if you do use a automated decision system, you must also preserve all the related data, including data about individual employees, employment decisions and outcomes, and the data used to develop or customize the system for the company, essentially all the training data as well. Second, potential third-party liability exposure is at issue. The new regulations broadly define agents as any individual acting on behalf of an employer to perform functions traditionally executed by the employer, including recruitment, screening, hiring, promotion, and compensation decisions, even when conducted through automated decision processes. This means your AI vendors and developers, the company that provides your resume screening software or the interview analysis tools, they could be considered employers alongside you under California law. And the problem for you is that it doesn't get you off the hook and it creates shared liability exposure. Now, both you and the AI vendor could be involved in a discrimination lawsuit if the AI system has a disparate impact on any protected group. Additionally, the regulations now prohibit aiding and abetting discrimination through automated systems, meaning vendors can face liability for providing biased AI tools. But again, this doesn't protect you, it only increases potential liability when problems originate from vendor sources.
So moving on to workplace reality number 4, AI and reasonable accommodations. On the other side of concerns with bias, discrimination, and harm, we know that AI technologies can potentially improve accessibilities for workers with disabilities. I know I've certainly noticed that closed captions I've seen have improved significantly over the last few years. It's important to consider thoughtfully how AI interacts with people of differing traits, advantageously and disadvantageously. Using AI for things like skills testing, attendance monitoring, or evaluating productive time may necessitate providing reasonable accommodations so that disabled employees are treated fairly. The CRD regulations that we've discussed require that if an AI tool evaluating an applicant's skill, dexterity, reaction time, or other abilities discriminates against individuals with certain disabilities, you may need to provide alternative assessments or methods for candidates with a disability or other unique characteristics. On the other hand, you may also need to consider accommodations to allow disabled employees to use AI as a tool with an accommodation. If an applicant or employee explains that a medical condition would make it difficult to use AI, that individual likely has requested a reasonable accommodation, requiring the employer to engage in the interactive process and find a suitable accommodation if one exists. Please note that the new regulations specify that an AI-based assessment that is likely to elicit information about a disability can be considered an unlawful medical inquiry. So use discernment and tell your managers to use discernment in communications around technology use. You might need to think critically about whether the intended business purpose for the technology is outweighed by legal risk, insofar as it applied to an individual's circumstances. Remember, any automated employer obligation should have an escape button to allow for individualized inquiries and decisions on a case-by-case basis.
Reality number 5 involves allowing AI to substitute for human judgment. You hire employees you hope are qualified to do the work. You do not want employees you hire for their learned skill, experience, and honed judgment, passing off the bot's work as their own, and neither do your clients or customers. We need to be sure we think carefully about what we are delegating to bots and also ensure employees understand what they are and are not allowed to do in their roles with the assistance of generative AI. Everyone needs to understand who is using AI for what. Equally important, your AI policy and training program must be very specific about what can and cannot be delegated to AI, taking your constituents' data policies into consideration again as well. What do you do if you hired Jessica because of her Harvard MBA and learn that Jessica has been having ChatGPT write her business plans? Well, that depends on your policy, right? As an early, although morbid example under California law, doctors cannot delegate end of life decisions to AI. They can use AI to understand probabilities, possibilities, find relevant information or alternative courses, but they must use their own judgment to make the end of life decision. Many roles, judgments, and decisions are meant to be made by specific individuals hired to undertake them. And that's often true about lawyers. As mentioned earlier, in the state bar is promulgating rules to help us with notice, consent, documentation, oversight, and disclosures. Don't forget that employees need these things too. We cannot substitute human oversight of business strategy either, or let the business folks that we support get legal advice from ChatGPT. They will get what they paid for. If you're looking for a bedtime long read, check out this decision out of the Delaware Chancery Court that issued last week. It serves as a cautionary tale for executives who bypass legal counsel in favor of AI generated strategies. Krafton Inc., a South Korean video gaming company, breached its legal contract with founders of Unknown Worlds Entertainment, who developed a video game called Subnautica 2. And the court ordered reinstatement of the former CEO and the potential $250 million bonus earnout that Crafton was looking to void as part of the failed AI generated strategy that sought to redefine just cause and at will employment in a contract. Crafton's in house lawyers had advised against terminating key employees for reasons proffered by its CEO, who thought the game wasn't sufficiently ready in advance of the release date. The CEO turned to ChatGPT instead of its lawyers, liking its advice better, and subsequently relied on the bot to manufacture justifications for his decisions, which the court then painstakingly determined came from ChatGPT and not the lawyers. More important than where the information came from, the court ruled after a trial that the proffered reasons for anticipatory breach were pretext. And this was a very expensive blunder for the company. The court ordered that specific performance, including reinstatement, to correct the course and subjected the company to hefty fees and costs. In the end, the net always include human review of the results of AI-based decision making. And I happen to think that human should be a lawyer if you can afford it. Moving on to number 6.
So, reality number 6 is workplace surveillance, employee privacy rights, and morale. The AI revolutionized workplace is constantly monitoring, learning, evolving, giving, and getting feedback. And of course, there's a lot of upside to that. But you're going to encounter resistance. Among other things, AI tools can track email activity, meeting participation, keystrokes, and even employee sentiment through communication platforms. Have you ever wondered whether someone is looking back at you through that camera lens? AI can tell if you're paying attention, to say the least. It's kind of creepy, right? Businesses, though, have many good reasons to want to surveil employees, with safety and security being among them. But let us not forget that California law requires careful shepherding of consumer and employee information. Provide employees with appropriate notice of the information being collected and its purpose to reduce risk. Remember to keep the data collected about employees supremely secure, or significant consequences can follow. How AI is used and how its use is explained to employees is crucial. Cornell published a study about employee morale in response to AI monitoring. The study found employees monitored by AI had increased complaints, worse performance, and higher turnover due to their having a reduced sense of autonomy. Employees felt that AI evaluations lacked context, making it difficult to understand their performance from their perspective and raising concerns about how management will view their AI reported performance, again, without context. The automatic nature of AI evaluation created a fear of being judged without the possibility for nuance or human interaction.
Speaking of privacy considerations, if you are a covered employer, you will need to be in compliance with the California Consumer Privacy Act's regulations regarding AI by January 1st, 2027. We will explain these regulations as they apply to you as employers, but depending on your type of business, they might also provide obligations to your customers or clients if you use AI to help make decisions regarding lending, housing, or healthcare services. Who do these regulations apply to? Covered employers are those with $25 million or more in gross annual revenue, businesses handling data of at least 100,000 consumers or households, or those that derive at least 50% of their revenue from selling data. These regulations govern when covered employers use AI to make quote unquote significant decisions, such as hiring, promoting, or compensation decisions, or disciplining employees. So if you're a covered employer, before deploying AI for significant decisions, you must issue a clear and accessible pre-use notification to affected individuals, including job applicants and employees. The notice must explain the purpose for which AI is being used, how to opt out, or if there's an exception to the opt-out right applicable, an explanation of how to appeal the AI decision to a human reviewer, a description of the employee's right to access relevant AI data and how to use that right. There are non-retaliation rights under the CCPA, and a description of how the AI works to make a significant decision and how the significant decision would have been made if the employee opted out. There are also requirements regarding how an employee's request to delete their information that you input into AA goes down. Importantly, covered employers must conduct a detailed risk assessment before engaging in any activity that presents a significant risk to a consumer's or an employee's privacy. The regulations highlight the following activities: selling or sharing personal information, processing sensitive personal information, although there is an exception for employers processing personal information of employees for the purposes of administering compensation payments, determining and storing employee authorizations, administering employee benefits, providing reasonable accommodations as required by law, or wage reporting as required by law. Please note, if you have questions about these CCPA requirements, contact us or your privacy counsel. The risks can be significant, as you could be subjected to penalties per violation, $2,500 per unintentional violation and $7,500 for intentional violation. So those figures can really add up. Just think about the numbers in that Workday case.
Moving on to workplace reality number 7, AI changes the performance management game. As found in the Cornell study mentioned in reality number 6, employees are more receptive to AI in the workplace when it is framed as a tool to support personal development and when context is given for the beneficial ways the AI will be used. So think uptraining. We spoke about AI having disparate impacts, perpetuating biases, and making mistakes. Still, AI can be extremely useful for managing employee performance. Unlike supervisors, AI can stay focused consistently and reveal anomalies or patterns almost instantly. Where relevant, frame AI monitoring as a tool to help employees grow and improve their performance, not just to judge them. Allow employees to understand and contextualize the data gathered by AI rather than relying solely on automatic evaluations, and implement AI in ways that respect employee autonomy. Human oversight is crucial, so please ensure that your AI policies reflect requirements for cross-checking, verification, and certainly provide employees with notice about how their performance will be monitored and measured. Lastly, provide opportunities for employees to correct or explain information before making employment decisions based on AI's observations.
Workplace reality number 8, AI and pay equity. Assuming data security, AI is a powerful tool to check your compensation structure for disparities among protected classifications or generally. However, it can easily serve as a tool to create disparities or other problems based on flawed design or inartful execution. AI should make your equal pay analyses more efficient, but AI cannot replace the critical forethought and verification that human beings perform uniquely, at least until we achieve singularity. And I understand the jury is still out on when that will be. The bots will tell us. Meanwhile, think about how you classify demographic information incorporated into your equal pay assessment. For example, grouping employees by zip codes again and ensuring parity within a region can perpetuate systemic issues and undervalue employees. The same can be true conversely. We can do a separate presentation on constructing an EPA analysis using AI while mitigating risk. But I want to emphasize that in-house counsel need to weigh in to consider attorney-client privilege waiver issues depending on how AI is used and the nature of the tool used. In addition, the CRD regulations we discussed earlier require ADS-driven decisions to be job-related and consistent with business necessity if they result in a disparate impact on protected groups. Also, in a law that didn't pass last year, but we believe will be back in some form this year, automated decision systems would not be allowed to inform compensation decisions unless the employer can clearly articulate or demonstrate that differences in compensation for substantially similar or comparable work assignments are based on cost differentials in performing the tasks involved, and the data used was directly related to the tasks the worker was hired to perform. It would prohibit using an ADS to conduct predictive behavior analyses defined as any system or tool that predicts or infers a worker's behavior, beliefs, intentions, personality, emotional state, or other characteristics or behavior. It would also require, like everything else, a human reviewer to conduct its own investigation and compile corroborating or supporting information for the decision. It would require notice of AI use before and after, with a civil penalty for noncompliance. It required disclosures to employees about the law's requirements and add an appeals process for employees affected by the ADS decisions made.
So at this point, you might be asking yourself, where are the deep fakes? When are they going to talk about deep fakes? Well, the deep fakes come in at number 9, turbocharged harassment. So AI tools like deep fakes and voice cloning are creating new forms of problematic workplace harassment, and their sources can be hard to track down. As you likely could have surmised, sexually explicit or humiliating images or videos of employees can lead to a hostile work environment and legal action under the FEHA. I personally find that criminal liability is a strong motivator for employees to update policies and practices. So please take note that California's SB 926, which passed in 2024, made it a crime to create and distribute sexually explicit deepfakes intended to cause emotional distress, and this law applies to conduct in the workplace. So we saw this in a recent case in Carranza versus the City of Los Angeles. Carranza was a captain in the LAPD, and she found out that a number of LAPD employees were passing around an AI photograph falsely said to be of her that was topless. She explained to the LAPD and asked, or sorry, she complained to the LAPD and explained that and asked them to tell everyone the AI photograph was not her and direct employees to stop sharing it. LAPD did not do anything, so she decided to file a lawsuit. Not surprising. Only after she filed her lawsuit and 9 months later, LAPD finally decided to start an investigation and found that the complaint was valid and that passing around this fake AI photograph of Carranza was a violation of LAPD's sexual harassment policies. Also, not surprising, this was too little, too late. The jury awarded $4 million in past and future emotional distress damages, and the Court of Appeal affirmed based on LAPD's lack of response to Carranza's complaint. So please think about your investigation processes and tools. Consider using AI to spot AI deepfakes, but only if you can do so while ensuring privacy and avoiding placing anything into the wrong hands, let alone the public domain, which could lead to severe legal consequences. From my perspective, it is much more difficult these days to make credibility or fact determinations based on visual evidence alone because it is unfortunately easier to make up false evidence. So think in advance about how you want to handle potential harassment and hostile workplace claims, even in the form of circulating a made-up image, and address potential harassment and other workplace violations, even when the bots acted as the middleman. As a litigator, I also cannot help but to remind you to ensure that any investigation of electronic harassment takes into consideration the preservation of metadata for evidentiary purposes.
I think that metadata will become increasingly important as time goes on. Workplace reality number 10. With all the efficiencies businesses have gained and are gaining, there's no denying that reductions in force are following adoption of intelligent automation. In many cases, job roles can and should evolve to adapt to the age of AI, and smart job description updates should follow, and they can help set up the boundaries mentioned in the title of this segment. Please don't forget the WARN Act and CalWARN, or the Older Workers Benefits Protection Act, when eliminating positions. Ensure that selection of candidates for a reduction in force meet objective criteria. Don't lean too heavily on one protected classification of person more than another, at least without tying it to legitimate business necessities and operational realities that underlie the reduction in force. As a side note, another side note, the EEOC recently updated educational materials in a one-page technical assistant document issued titled Discrimination Against American Workers is Against the Law, to reinforce that Title VII's ban on national origin discrimination applies to all workers, including U.S. citizens, and that common business rationales, including cost cutting or visa status, do not justify discrimination. The guidance thus emphasizes that practices favoring workers of a particular national origin, including preferences for certain visa holders over American workers, may violate Title VII with compliance expectations clearly outlined for employers. Just when you thought you had all the protected classifications down, you got to think about this. But I mention that because AI, we are seeing in the work that we're being asked to do a lot of layoffs already. Recall that AI can be a useful tool if we oversee it with critical thinking, and that the human needs to review all of the considerations underlying the selections of a risk. We got to check for disparate impact, irrespective of AI's, usefulness for putting together a RIF, and make sure that we are making legal assessments that are consistent with our obligations in play, irrespective of competing interests. So, human lawyers, please ensure that protected activity or classifications do not tend to explain the reasons an employee was selected for elimination. And please seek advice in the early planning stages of a RIF business case so that we can determine whether appropriate selection criteria are being used and confirm employees satisfy that criteria. Seeking advice on preparing your communications to affected employees as well. Corinne and I want to leave you with this before we open up the floor for any questions. If you decide to use AI for important employer functions, please conduct periodic audits of all of the functions that you delegate to look for patterns of disadvantages, even if you're not required to do so by the law yet. Offer qualified candidates and employees with disabilities opportunities to request accommodations around how AI will be used on them and by them. Lastly, even if you have deep concerns about how AI is used in the workplace, play with it, using information that is not private or sensitive, of course, and learn how it can do your bidding the right way. This requires using at least 3 scene setters in your prompts to improve the application of your results, and take control of the bots to keep them in their places before they get you into trouble. And with that, Corinne and I would love to hear from you, and we'll leave the mic open for any questions or comments.
And while we wait for any questions, thank you for your attention. Please don't hesitate to contact us or any of our Wilson Turner Kosmo colleagues to learn more about how you can shore up your boundaries, protect your workplace from unlawful bias, and mitigate legal risks. You should be receiving our written material soon if you haven't already, along with information about continuing education credit. And I'm not seeing any questions in the chat, but if anyone wants to ask some questions or jump on, we're happy to answer them. And but otherwise, I think you can